Can the court order you to get drug testing? Hi, I'm Alicia Kinchlow, the owner of Kinchlow Law, a family law practice based in the Philadelphia area. One of the 16 custody factors is whether or not there's a history of drug or alcohol abuse by the parties or anyone in their household. And sometimes people will ask, well, will the judge actually order the other person to get a drug screening? Or will they order me to get a drug screening? And the question really comes down to what the judge thinks is at issue in the case. But simply, the judge can order you to do so. So, as always, you want to speak to an attorney licensed in your area about the facts specific to your case. You want to understand when you walk into court what could happen. Now, back when the courts were open to the public, and even in some situations now where they still have some limited proceedings occurring in person, the court can order you in Philadelphia County to get a drug screening forthwith, which means you can be ordered to leave the courtroom right there, go upstairs to the 8th floor in Philadelphia Courthouse, and get a drug screening. And sometimes the court will pause the proceedings or hold the proceedings until you go and get that done, and then you come back because the judge may want to look at the results of the drug screening before proceeding with the case. And sometimes this is where there's definitely been some issue in the past, some concern, but where at least one party has made allegations, either verbally through testimony, presented some evidence, or where it's named in the pleadings. Or and sometimes the judge may do it on their own because of the behaviors that they have witnessed in the court. I've had that happen before where the judge has noticed that a person was behaving bizarrely and asked them to get a drug screening done. So you need to understand that you could do that, that it could be ordered right away. And if you don't submit to the drug screening when the judge asks you to do it, it can be treated as a positive. So skipping it is not necessarily the best way around it either. Now, what happens if you actually take prescription medication that might suggest a positive? So maybe you take some type of opiate medication for pain or for something else. You generally want to advise the court of that, let them know it's prescribed, so that when that shows up in your drug screen, it will not be a surprise to the court. Now, again, speak with your attorney about the facts specific to your case before doing so, but that is a tip that I give my clients just so that the court is not surprised when something like that shows up. Now, in other counties, for example, in Delaware County in Pennsylvania, they have you submit to a follicle test. And in that type of situation, they're looking a little bit longer to see how long ago you used drugs or alcohol, and maybe the levels, and how long it's been going on. So as long as you have some hair on your body, they can be able to tell when you last used drugs or alcohol. And again, a lot of these orders come with parameters around them. So again, if they say forthwith, that means go right now. And sometimes they say you must submit to within 48 hours of whatever notice you get. And if you don't do that, again, it'll be treated as a positive. So you want to make sure that you are complying with the request of the judge or the master who's ordering you to do that. Now, another thing that they look for will be whether or not there seems to be the presence of a masking agent. So if you try to go in and use some type of substance or do something else to try to hide your past drug use, those are things that are kind of looking for as well in your drug screen. So you should be on the alert for that as well. The factor of drugs and alcohol is important because we can understand that someone who has a problem with substance use or abuse will generally have an impaired ability to care for children. And that's why it is one of the factors the court must consider. But you also should know it's not just you the court is concerned with. The court is also concerned with other parties in your household. Now, while the court may not be able to bring them into court and order them to get drug screening, evidence that there's a person in your household who has a substance abuse problem and that substance abuse problem has caused issues or poses a risk of harm to the child or children, that is something the court can and will consider in making a custody determination in your case. All right, so I hope you found this video helpful. If you have any questions, any comments you'd like to leave about today's subject on drugs and alcohol testing, please put it in the comments below. If there are other videos you would like us to to touch on, or the issues you'd like us to touch on in our videos, please leave that in the comments below as well. These videos are here for you. Make sure you hit subscribe and the little notification bell so that way anytime we drop a new video, you'll get the new video right away. And we're doing one every day of 2021 on custody, support, and divorce. All right, until next time, take care.